Ms. Reed.
Thank you, Your Honor. I have reviewed the recommendation from probation with my client. Obviously, there is a 60-month probation recommendation, which is quite serious, and she is understanding that she will have to comply with that. There's also a 15-day jail recommendation, and Ms. Jefferson would just like to ask if there was any way for the court to suspend that, as she has significant health issues. She is a person that multiple people in her family rely on for support, and she is also presently the only person at her place of employment, and would cause significant distress for them as well if she had to be taken into custody. She would lose her job and lose the stability that she provides for multiple family members. As I said, there is also a recommendation for 16 months of probation, which is 5 years and is quite significant. If she does understand it and is willing to accept that portion of the recommendation, and she is just hopeful that if there is any way for her to avoid any time in custody, that the court would be willing to consider that.
Jefferson, anything you want to say to the court before I impose sentence? And if you do, you need to come up to the podium. Counsel, you may want to join.
Good morning. Good afternoon, sir. Just to start off, Ms. Simpson, I would like to apologize for today, dates or whatever, the harm might be, whatever. I truly apologize from the bottom of my heart, because I lost my first child, especially the kids as well, but I would never abuse a child. So my thing now is for I accept whatever charge I was given. I was just asking as far as the lenience towards, like, my daughter just moved to Mississippi here. She came under a job and she got hired for it, and I'm the only one that can babysit my grandbaby at night. That's my only piece for 15 days. If I do 15 days, I'm probably my job now. That's my own story. So that's all that is, ask the court to kind of please, be lenient towards the 15 days, whatever it is I'm given, I can, accept that. It could be lenient toward that. So it's like my daughter, she starts work, she starts her orientation this week, and like I literally have nobody to eat by my baby at night. So that's my only business for 15 days. Anything else, I take full responsibility. So that's all. I don't have much to say. I'm accepting the choice. Whatever the decision is, I'm accepting it. I'm truly sorry, I didn't mean for this to happen. I have a heart, I really do. So I don't want anybody to feel I have a cold heart, which I really don't.
Ms. Valera, you rose.
Yes, Your Honor. I just wanted to bring it to the court's attention. Some of the statements that is being made, I did take that into consideration when I made the recommendation for sentencing. I mean, the actions in this case, especially on a child that is 17 years old, I believe that there is a need or deserves some sort of jail sentence. And so with her situation, I did take that into consideration with the recommendation that I provided.
Thank you. Anything else? Court imposes sentence. Let me first start out by at least this court's last observation. Ms. Jefferson, as I listen to you start out your elocution, you turned around to Jace's parents and you, I guess the way I look at it, or what you portrayed to this court, was sort of a very sort of shorthanded shrift of what Jace's mom just got up here and said.
Yes, I understand.
No, I don't think you do. I really don't think you do. Because after making what maybe in words was an apology, but certainly I don't think in one's heart was an apology. Every next, ma'am, if you want to continue to, no, I'm just going to tell you, if you want to continue to allocute, I'll let you do that. Okay? I will let you say whatever you want to say to this court before I impose sentence. I will not be interrupted once I begin my sentence. So if you have more to say, please do. Well, thank you for allowing me to continue in my court. But after that, and I'll just call it what it is, because that so-called apology just now. Everything that then came out of your mouth was not about Jace. It wasn't about what happened that day. Everything that came out of your mouth was all about you. About why you can't do this, why you can't do that. And I guess that's fine because it's your sentencing, but that video, what you did to that child, I don't even understand, to be honest with you, how that whole process started out. I cannot even imagine what could be going through, and I think it might have been the driver, that individual, and then you. I just don't even know where the mindset starts to do what you did. I don't think you understand. And to do it to a child that already has challenges. I mean, Ms. Jefferson, it might have been certainly bad enough and would have been horrible had it been on a 7-year-old that doesn't have disabilities, doesn't have those things in life that make sometimes life difficult, who could maybe verbalize to you what's going on. That would have been bad enough. But you have Jace. Some of those things he can't do. And you know that. I mean, that's part of the problem. You know he can't. And maybe in some bizarre twist for you that made it okay because he can't tell. Because he can't, in some ways, verbally defend himself. I don't, even if in the moment, and I don't think this is the case, but even if in the moment you...
This is where everything turns. The judge points straight at the evidence and shuts down any excuse. No hesitation. No authority. The way it happened doesn't look accidental, it looks deliberate. And now the focus locks in. This is no longer about explanation. It's about answering for what was done.
Sort of lost control, lost your head. Because everybody, that happens. But then what people do is they reflect upon what they've done. maybe one advantage to you reflecting upon that is that there's a video of what you did. I listened very closely to the testimony that was in the case, and not only on a certain level should you have not done what you did, but you weren't even authorized to use the instrument that you used to do it. You didn't have the permission to do that, but you just did it. And I'm going to tell you, as it happened, it was almost as if it were planned. That's what was going to happen that day. Because as I looked at everybody kind of moving around, and there wasn't any hesitation, any like conversation that, well, let's do this because this is, it was almost as if I'm going to hand you this child, he's screaming, and we're just going to, I can't put it, we're just going to strap him down. That's what we're going to do. Not for a good reason, as if to make the child's life better, but solely to make your life better and easier at that moment. Jefferson, some people don't think maybe I'm paying attention sometimes, but I watched you watch how you acted through that entire trial. I listened to you today. And I have to agree. You have no remorse. You have no understanding of what you've done. None. One thing when people are sitting in a trial and certain evidence is coming out and they react a certain way. But typically, especially in cases like this, between the time that happens and I pronounce guilt and the time of sentencing and the ability to have conversations and again, to reflect on what may have happened, they change, or at least have an appreciation for what happened, or at least an understanding for why people may feel different about what they did. Regrettably for you, Ms. Jefferson, and maybe regrettably for us all, I expected to see that from you today. But regrettably, I didn't. I didn't in your voice, in what you said, in anything. See any caring or concern about what you did to the child. And I don't, some ways I don't understand that lack of feeling. She got up and what she was saying to me, and I get it. I come from a long line of educators too. Primary job. It doesn't matter. They can be kindergartners, they can be college students, they can be whatever. The primary job of that instructor or that person in the courtroom is to protect those children. And in a lot of ways, as my parents would say to me, that's because that's somebody's baby. But she got up here and I have to give her credit because I'll be honest with you, if that were my child, I do not know that I could have even tried to address it. She got up here and spoke as a mother, not necessarily as a victim, or she spoke on behalf of her child. She spoke as a mother. And I don't know how a person hears that. And as I look at you even right now, it has no effect on you. It is as though you don't care. Typically, when I'm going to sentence somebody and I have absolute trust and faith in my probation department, what they take into account, what they don't take into account, and in terms of fashioning their sentence. And I appreciate what Ms. Flair has said, because I know how she works. I know that she has taken everything that everybody, all of that information, taken it into account and synthesized it into the sentence. It is a sentence of the court. You will serve 60 months probation.
Now the consequences start stacking. The judge tightens every condition, control, restrictions, accountability. Then the tone hardens. Job loss doesn't matter. Personal hardship doesn't matter. What matters is the harm done. And as that lands, the courtroom shifts. This isn't negotiation anymore. This is the sentence taking full weight.
You will pay $655 fines and court costs, $1,800 probation oversight fees. How are you going to pay that, man? It'll be a payment plan as arranged by probation. There is to be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You are to complete the anger habits program. You are to complete 50 hours of community service. You're to complete 100 hours of community service. I'm changing that. There's to be no contact with Jay Swookie or Jamie Nelson, directly or indirectly. Do you understand that, ma'am?
Yes, sir.
There is to be no use of any type of corporal punishment toward any child. You understand that, ma'am? There is to be no assaultive, threatening, or intimidating behavior. You are not to possess any weapons, firearms, or ammunition, or anything fashioned to be a weapon. Do you understand that?
Yes, sir.
You are to report to probation as requested by probation, and that will include any home visits. You're to maintain employment with verification to probation. With regard to the jail sentence, ma'am, you know, and I don't mean to be flippant about it necessarily, but I'm just going to tell you this. I don't really care if you lose your job. I really don't. Because what you did to that child that day, what you did to somebody's baby that day, in my mind is inexcusable. Any harm that any jail I impose upon you causes doesn't even compare to the harm you caused that child that day. One day, that 15, 20 minutes, the harm you caused that child. Nothing that you will go through will compare to that. And you need to understand that. And if it takes you a while to sit in the Washtenaw County Jail and think about it, well, I got 300 160 reasons why you may have to start thinking about it. Court orders 365 days in the Washtenaw County Jail. I will give credit for 2 days served. Defendant is remanded to serve an additional 30 days as opposed to the 15. Defendant, and then the balance will be suspended. Defendant's remanded. Anything further, Counsel?
No.
Thank you, Ms. Blair. That's it for us for today.
Yes.
Thank you.